Hello, everyone. I'm Vince White. I'm an employment attorney. On this channel, we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney, but not today, because today we have something special for you. I'm here with employment attorney Francisco Fernandez, and we are going to talk a little bit of shop through some hypotheticals as we help each other brainstorm and work through cases. And I love showing this in the same way I love showing when I bring in defense attorney Eric Sarver or in-house attorney Ivan Hanel. I love showing the perspectives, but the way that in-house attorneys and defense attorneys think is always going to be different from the way plaintiffs attorneys think. And that's why I think this is amazing. I think having this for you is valuable. And I'll be frank with you. There's exactly two plaintiff side attorneys willing to do this with me. And here we have one of the finest. So I'm very excited about this. Sir, where should we begin?
Sure. I wanted to talk about the situation in which you're representing someone who's currently employed, and the goal is a negotiated exit, and the pros and cons of that situation, and what the right strategy is, and how that strategy might differ from the strategy when you represent an employee that's been fired.
Quick question before we go on. Does the employer know paid exit is your client's goal in this hypothetical?
Uh, so this is at the very beginning of the representation when you haven't
Okay.
sent any correspondence.
Amazing.
So,
Okay.
but you're going to announce that in due course.
Okay. Understood. All right. Please continue.
So, what I like about that situation is that employers and defendants are repeat players who are represented by sophisticated counsel. Employees are not. And if you're representing the employee before they've been fired, you can help them take steps that are going to protect their claim, that are going to reduce risk. You can coach them through the process and help them in an honest and fully ethical way engage in protected activity if it's the facts fit that, and not to mix in their complaints about protected activity about with workplace injustice or bullying or drama or things that might be construed as not having to do with protected activity or protected category.
Yeah.
Because that's something I've seen in representing employees who've been fired, is that there will be a long email about how awful a manager is being and lots of workplace grievances. And oh, by the way, I'm being called racial slurs. That's not acceptable at the very end. And it really, I don't love that for them because it really diminishes it.
Yeah.
Well, it harms their claim.
Yeah. It knocks the legs out from some of what they're saying because their chief complaint wasn't the valuable one.
So, given that you've got a ton of experience in this field, I was just wondering, like, what is your approach to those situations? How are you creating value for your clients in that situation? What is your sense of like what the right strategy is there when it's kind of it's a quite a delicate dance, and sometimes actually the companies might even retain contractors who are attorneys to run the investigations.
Mhm.
And that, that let me make sure my email is closed out so we don't get those beeps again. They sometimes that I've noticed that companies sometimes will retain investigators, third-party contractors who are attorneys. So I imagine there's a lot of privileged communications that are going on about my clients and a potential departure or a potential termination. So you know, it also what a little bit gives me pause about those situations is like once you send a letter saying we want to negotiate an exit, there's no putting that toothpaste back in the tube. So I just wanted to know how you kind of talk through those situations with clients and what's your, to the extent you're comfortable sharing on a public forum like this, like what's your strategic approach in that slightly different situation than representing an employee who's been fired.
Okay. So right off the bat, excuse me, I've got four things I want to talk about. Um, you zeroed in on the attorney investigators, which is a big trend in our industry right now. especially in the past 2 years, I've been seeing a lot of these outside contractors, defense attorneys. It's a new cottage industry. It started with a couple of firms that fractured, defense firms that fractured, and they started doing it. I saw in some of the big markets, LA, New York, probably in Chicago, although I'm not familiar with Chicago because there are good attorneys such as yourself in Chicago and the outlying areas. And that was something new that we had to contend with. And to your point, they are much more savvy in how they handle these cases from an investigation standpoint than your average HR professional. I think you might agree, right?
Definitely.
But there's two things going on. One, you put your finger on it. They're trying to create privileged, they're trying to add privilege to the investigation process. We have had considerable success defeating that. Not 100% of the time, but our firm and a couple other firms that I've seen have created case law being like, well, actually, this is not really attorney work. Like, attorneys don't investigate. So therefore, why would there be privilege here? You're just this person happens to be an employment attorney, but in this moment, they're behaving as a private eye or an insurance investigator or an HR professional, right? So we've had some success with that. The other thing we've been doing is bumping it right off the bat with a letter of representation. Like, hey, this person's represented. There is an ongoing conflict. We expect it to be in litigation. And in many states, although I'm not familiar and nor could I speak to the ethical rules of your state, the attorney conducting the investigation, who is purporting themselves to be an attorney for the employer, can no longer speak directly to your client without you present in many jurisdictions. So we've had a lot of luck with that, where they will immediately say, oh, we can't perform the investigation anymore, or the attorneys can't. So they'll send either someone else or they'll suspend the investigation. So both of those tactics have been invaluable in combating this new, I always think of it as almost like a video game, like this new tech branch in the world of employment law. Like the defense attorneys and the employers of the world unlocked recently, like new NDAs, outsourced investigative attorneys. Like these are new things that they're bringing to the table. And in the arms race, we're like, oh, we better figure out responses for this. Cause like, I definitely saw a couple of cases get just wrecked by attorneys who are like, I'm going to litigate this later, but right now I'm going to investigate it. And they did great jobs, you know? So we were scrambling to get a response. And those are two of the things we've been doing. And there's definitely more we have to figure out on that front. But I would love for some of those tactics to get out there. The next thing, and I was just taking notes here. So I love the way you're talking about the scenario where you're helping you're supporting the person and engaging protected activity. I love that narrative and I love what you're doing there. That is, everything is correct. I know a lot of attorneys who would say, oh, no, I'm manufacturing a case. Dude, you are not. You are not manufacturing a case. There is a case. There is legitimate discrimination. You are helping this person to oppose it. That is not manufacturing a case. That is you supporting a human in defending their human rights. And it might make the case stronger, but that's not what you're doing. So stop talking like that. That drives me. I used to have a guy in my firm who would talk about this, and like, good attorney, but like so cynical. And it was just, you're not manufacturing cases, man. The case is there. Nor do we have to manufacture cases. Like, there's too many cases. It just, so I love the way you're talking about it. Quick thought from me, and I don't know if this works. You mentioned your early letter is going to have to disclose that your client wants a paid exit. Counterpoint, why? Why does it have to? You could fake a desire to stay and work that retaliation trap, right? You've got the protected activity. Your client's reasonably safe from negative workplace consequences. The employer clearly wants your client out. The retaliation aspect is going to be a disaster for them for years to come. Fake like you want your client to stay and let them pay a premium to get your client out, which is the only real way barring your client really messing up, that they're going to pry your client out of that job. Just a
Hmm.
thought.
No, I like that. I like I've been thinking a lot about information asymmetry in employment law and the
Yes.
fact that
Yes.
you have to
Sorry.
deal with paid like employees of the defendant are in my view are essentially paid witnesses. And I think that's why so many employment law cases lose on summary judgment because the incentives are just brutal. And I've been thinking a lot about how to overcome that situation. I do think representing employees pre-termination is actually a step. It's not the full solution, but it's part of the solution.
Yes. I'll tell you right now, it has done wonders for my life and for my clients, no question. It is, and I don't understand why nobody will adopt this. People, there's many things that we do that people are like, that's disgusting, Vince. You do disgusting things, right? Like
Mm.
holding the client in there and being like, hey, if you can stay here, if you can hack this, if you can survive in this really conflict oriented environment, we can probably get a premium. People be like, Vince, that's disgusting. Like, no, not if my client is okay with it, right? You tell the client, listen, this is going to be hard, but if this is okay for your well-being, it will also be a great source of leverage, right? Um, People, when we hire private eyes to look into bad actors, people are like, you're disgusting. Okay, I mean, I guess, but my job is to make my client money. And
Why? Why? I don't understand at all. Why would you not
no,
be as
it's so weird.
aggressive as?
Okay, I'll give you another example. We had a bad actor in a big company, and our client was like, listen, he's done this to like 7 8 different women, and like this guy would go around, he would get subordinates wasted and he would bang them, and like they probably realistically couldn't consent, they were too drunk, and he
Mhm.
would, while they're drunk, promise them jobs and all this shit. And our client was like, listen, no identifying characteristics, but like he did it to me, he's done it to these 8 other women. And I was like, great, well, we can't solicit them, but we can run ads. So we went ahead on LinkedIn and ran ads for everyone who worked at that company, everyone who viewed this guy's profile, everyone who previously worked for that company, and everyone who searched that company.
Hmm.
And this guy was high end enough, he's big exec, that it, one, hamstrung everything he was doing in his career, but two, applied this incredible pressure for our client, right? Because they wanted the ads down in the worst possible way. And people are like, you're Vince, you are the worst of this industry. And I say, I don't know. I think the metric is how much did I help my client? You know, I don't think the metric
Is
is
this
did
coming from fellow plaintiffs attorneys that are saying this?
occasionally, yeah, a lot of defense attorneys, but even plaintiffs attorneys will tell me that I'm disgusting. And I'm like, listen, I got a serial fucking rapist, pardon my language, and I got a client who I owe duty of loyalty to. So if I gotta
And
nuke the guy,
you're the villain?
I people act like I'm the villain.
God,
I had someone
okay.
be like, you behave like you're a mafia boss. I'm like, well, I'm not breaking anyone's kneecaps over here. Like, I'm leveraging the legal and ethical tools at my disposal to produce results for my client. And there's nothing wrong with saying, hey, if there's more victims out there, we'd love it if we could help you or help you find resources, or you could corroborate our client, you know? And there's nothing wrong with that. I understand that it might make that gentleman's life a living hell, but maybe don't be a rapist. Like that, I don't care about him. I will turn it, I will compost that man if it produces a result for my client. The end, right? And sorry, we're way off topic. I'm sorry. But yes, I fully believe. Can you tell what I've been dealing with this week? Um, I fully believe that the retaliation trap is kind of what I call it, where you're wedging them in there. If your client can hack it, and not every client should. There's some clients who just are not going to be okay in that scenario. But if they can
Hmm.
stay, if they can handle it, if they're predisposed to being able to deal with this kind of thing, um, it's a tremendous tactic. Doesn't listen, it's not perfect. There's no perfect
Hmm.
tactic, but I'll tell you, it's made my clients some money, no question.
How did the timescales work on that? Because I could see it being tolerable for a month or two, but maybe not on a 6 month type timescale.
So it's difficult. We have the advantage that data wise, most of our caseload resolves within 9 months.
Mm-hmm.
So, um, but I'll tell you right now, there's definitely people that I've had that tactic with where I put the note on the file, like, listen, 2 months max, got to get this person out. This is a short runway. Like, this person's okay today, but it's not going to last. Right. And
Mm-hmm.
you just have to be aware. I don't know. That's something I would look at here. Maybe. I don't know. Any is any of this useful? I feel like I'm letting you down.
No, geez, why would you think that?
I always tell you.
The uh, the
I'm insecure.
I mean, the thought about not disclosing the desire for a paid exit now, that is interesting. Um, that's not something that actually would have occurred to me, but maybe that's something viable here that ought to be considered when you're dealing with these kinds of cases, depending on the client's well-being, obviously. Um,
Always. And it's very situational.
and I think another thing to take into account there is how long the client thinks it's going to take them to find new work. Because if there's going to be a short transition, you need less money. Obviously, as the attorney, I always want there to be a bigger resolution, but prioritizing the client's well-being, if they know they can find a job in relatively short order, the size of the negotiated exit needs to be smaller. But if they're in a industry or their job is such that it's somewhat specialized and it's going to take a long time, that's a situation where maybe it's makes sense to try to hold out for.
Yeah. I mean, I am not one, and I'm routinely criticized for this by the attorneys that I work with, by my colleagues, where people say, like, oh, this person's going to mitigate in 3 months. Prove it. I just don't. 2024. I don't know if I
Mm-hmm.
believe it. Excuse me. And I do find that defense attorneys, listen, they make a lot of hay on that argument, but do they really want a federal trial? I mean, against you? Of all, like, I wouldn't, you know?
Mm-hmm.
So, yeah, I mean, I guess we can argue is mitigation going to happen in 3 months, 9 months? Well, the person stayed so that, there's less runway. I guess. I guess. But how much does that really move the needle in the scheme of things?
It only moves the needle for me in terms of like considering what might be best for the client. Like if there's a
Yeah.
high degree of misery and there's going to
Oh, yeah.
be and there's a good and you have a reasonable basis to believe they can mitigate quickly, you can take less money to get them out of there.
I would I would agree entirely. I would also say that is a client choice, right?
Yeah.
Like, listen, I roll this out, and I can probably think of 10 people I've done it with in the past 3 months where I would say, hey, this is what I'm thinking. And I think you could stomach this, but I don't know you. I don't know what's in your heart of hearts.
Mm,
And this is a decision about your well-being. And your
mm,
well-being has to come first. We have to treat your well-being as a slowly regenerating resource at best. It's barely renewable. It's renewable in the long term, but in the short term, barely renewable. That's how slowly it regenerates. So, like, can we do this? Is this gonna ruin your marriage? Is this gonna make you different with your kids? Is this going to make you unable to enjoy life? Like, what? How is this gonna hit you? Can we do it? And some people say yes, some people say no, some people say yes, and 2 weeks later they say no. And that's okay because maybe you got some advantage in those 2 weeks. And now you say, you know what? We've had enough. Uh, we're open to hearing about a paid exit. I suspect you want a paid exit. We're open to hearing about it at this point. And listen, you still have an advantage, and you can still kind of allude to the fact, like, listen, my client will stay. My client will stay forever if my client doesn't get what my client's looking for.
mm.
And I have been, I've repeatedly been called out for saying things like, my client will have my card in her or his wallet for the rest of their career in your workplace, and they have my cell, and they will get someone from my firm on the line within 20 minutes, 24/7. The next time someone looks at my client cross-eyed, you'll have a new case, you know?
Mm.
And it moves cases. It does. in my experience.
Well, you know, I'm about to get into it, and we're going to see how it plays out. And but I'm excited to start representing some of these people because in the past I've been telling people, you know what, I've been giving them some free advice and saying, but I can't take your case right now. You haven't been fired. You don't really have any damages. Um, I think it's a big mistake. I think it's a big mistake because these
Yes.
clients are not employment attorneys and they may be experiencing genuine discrimination, but if you couch your complaint about discrimination in terms of like TPS reports, I know you're fond of that turn of phrase, but if you have a lengthy email about the TPS reports and at the very end you say, oh, by the way, this is harassment, discrimination, and bullying, you can just destroy what otherwise would have been a good case.
I can I can tell you this. For a long time, defense attorneys would come and say, client's not even fired. What are you doing? And
Hmm.
they don't say that to us anymore. What they say now is, I know what you're doing. And
Well, I
and
mean,
it's
why
like,
is it why is that so unsavory? Like, defense attorneys, and they should, are zealous in representing their clients. They take every advantage they can get. They exploit the
oh
information
yeah.
asymmetries. They exploit the paid witness problem. I spend a lot of my days now, not a lot, but like at least, I try every day to read one summary judgment decision.
Ooh,
Um,
that's amazing.
and most of them are not good for the employee, unfortunately. Um, and I've seen the tactics that are being used, and they're exploiting the paid witness problem. They're exploiting the information asymmetries, and there's such an uphill battle as a plaintiff's attorney. I would even go so far to say, as you're ethically bound to take every single possible advantage you can for your client.
I agree completely. So I do, and this is silly, but it seems to get traction. I imagine our role as these little monsters for hire, right? Because defense teams are going to be 3, 5 attorneys.
Hmm.
Our teams generally max at it 2. If it goes to trial, I'll detail a third, and I suspect most firms are not even doing that. Um, we're always outnumbered. We're always outspent. The employer, there's no employer. I can't even imagine the employer that we would go after that doesn't outspend my client, let alone my firm. You know, um, we have worked on cases where I know for a fact the legal bill for the defense side for just that single case was greater than the revenue for our firm for a year. Sincerely, right?
Wait,
So
what are these people thinking? Like, why are they spending these king's ransoms defending cases that they could resolve for a fraction of that cost?
so sometimes some people are so valuable that you can't let them take the hit and you can't settle for them because it looks bad, like it, and
Mhm.
or listen, some I've seen great example. We had a mom and pop business where the son did some bad things.
Mm.
And mom and pop couldn't accept. We had pictures, we had text, we had everything, right? Like there's no question. Mom and pop, we're gonna bankrupt the county to save this kid, right? And you and the war chest on our side that gets involved in a case like that, where they're well into the 7 figures on their spend, right? A videographer at every deposition asking for 35 depositions, right? What?
30,
Really?
35?
They sought 35. It might have been 37 depositions. Videographer at every one, specialized outsourced deposition attorney who joined the defense attorney team, not even a member of that firm, a specialized deposition attorney. They brought in, there was a witness who was gay, and they brought in a specialized gay defense attorney to try to slut shame the gay witness. Like
Unbelievable.
literally like
Unbelievable.
asking comments like, how many people have you slept with in that office? And the witness is like, what? That doesn't have anything to do with this. What are you like? Crazy, crazy stuff. Um, and the spend was insane. And I mean, what do you do? You have to be the little monster, right? You have to be like, okay, but like I can just destroy you. Like we can play the litigation game, but I gotta tell you, your son's never gonna date again. He's never gonna go on a dating app. He's never gonna be working anywhere but for you for the rest of his life. We can do damage. That's not the goal. The goal is to give the client the result. That's the goal. But if you're gonna try to bury my client with money, I could just nuke you. I mean, that's kind of what the press is for, right?
Mm.
So, not that we extort anyone, but like controlling the public narrative has value for our client. So we might have to, I don't know. It just, I'm excited. I'm so excited for what you're building and what you're doing. It's why we've been sending people to you. I'm really excited about this.
Thanks, Vince. That's great. I'm just sort of mildly horrified for you, just the amount of attorney time and money you must have in that particular case. But
It,
um,
it worked out.
it worked out. All right. Okay, good. I'm glad. I'm glad.
Yeah.
Yeah.
It has not always worked out for me. There's definitely
Yeah.
been cases where we lost six figures of spend,
Ooh.
but in aggregate, it's a great business in aggregate.
Yeah.
The biggest problem with this business for me is that I'm not ever going to be the victim of discrimination. So I always look like the problem. Beyond that,
Mhm.
the only issue I've ever taken with this business is the way clients treat plaintiff side attorneys. And I don't know if
Mhm.
you've experienced that yet, but that is a major negative in our field, and everything else is amazing.
So I did recently transition from pure contingency because I do represent a lot of lower income folks, but I've just had them pay a symbolic amount up front
The
or
symbolic
agree.
amount matters, really
Yeah.
does. It makes them value you more.
Yeah.
I,
No,
I
it's
yeah,
and I think it does deter people who might be less than truthful.
it that so I've been flirting with the idea of because we purchased another we're purchasing another practice of very good attorneys who I
Mhm.
worked with for a long time, and we've collaborated with them. We're very happy, to bring them on. And one of the main issues of my life is being able to staff properly with the people who we're going to run cases the way I want, and have the density of soul that I want to bring to this situation. Um, but I lost the thread of my point here. But essentially, I just don't think people approach this industry with the the reality of the situation. Like someone's trying to take your client's home. Like this is how they put a roof over their head. This is how they
Mhm.
feed their children. And and that means that sometimes your clients will behave in a way that is fearful, like they're cornered with their back against the wall, and they'll do things like try to steal your contingent percentage, or they'll lose their mind on you and take a swing or spit on you when you're like, listen, you lied to me. I can still get you 30 grand, but like you lied. Like those are tough conversations because what that person's hearing is, I'm gonna lose my house. Right? That's not what you're saying. You're saying, hey, here's the reality of what you did, and here's what I can produce for you. But what that
Mhm.
person's hearing is, oh, you want my kids to starve, right?
Mhm.
So that little bit of investment, for whatever reason, gets rid of all the lies, 99.9% of the lies that come in. You can just see them. You're like, okay, take our symbolic retainer up front. And like anyone that you're having doubts about, their eyes just glaze over. They're like, nope, I'm gonna go somewhere else. Cool. I'm excited for you. I hope you win. Um, but also we give it back. Like we don't really want to keep it. Like
Mhm.
it's not how we make our money. Frankly, it's a fraction of what we spend on a case, right? So it's like, okay, we take it, and then you're just going to treat us better, and you're not going to hit on our associates. You're not going to we had somebody kidnap an associate once. You're not going to spit on Vince. You're not going to try to have fist fights when we say, hey, listen, I hear that you want 30 mil, but I see 175K. Like you can tell us we're not going to be your attorneys anymore. That's a perfectly fine response, but you can't fist fight us. And like the symbolic amount of that chart, like I just never had those experiences after we started doing that. It was huge. It was huge for us. But I am flirting with the idea of going back to pure contingency for at least some component, because the firm we're purchasing did that pure contingency, and they were happy. Like they weren't like I miss it, but I don't think
Mm.
many attorneys can do it and be happy. Like the way they get treated. But this crew, this team was doing it, and when you speak with them, they're like, "Yeah, it's great. You're helping people." You're like, "Okay, if you can do it, I mean, it's what I want to do. I don't want to charge people. That's not what I want. I'm only doing that for quality of life, right?" So, yeah. Sorry, that was a long rant. Um, anything else we can cover today?
No, I think that's all of it. As always, Vince, it's a pleasure talking to you. I appreciate your
Pleasure
time,
talking
and
to you.
yeah,
Please send us your link tree. I want people to be able to contact you. Where are you accepting cases now? What's the full geographic area?
Illinois.
It's great talking with you. Your link tree down below. I hope this was useful. I think you brought more to the conversation than I did, frankly. It's always great talking
Oh,
to you.
Vince, give me a break. Come on.
No, 100%. Sincerely. It's awesome, man. I'll talk to you soon. Okay.
Take care.
Take care.